I can't fake it. I can't fake it. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. Yeah, I'm down. Trying to turn that frown upside down. Some Baldoni Dragons supporters are very excited about this. I'm not. Jen Abel, Baldoni's publicist, has filed a motion to compel against Vanzan Inc. You know Vanzan, the company that was behind that sham subpoena. The subpoena that legally allowed Blame Lively to be in possession of Jen Abel's former texts and emails when she worked at JonesWorks, the previous PR company that he fired. Stephanie Jones of JonesWorks is suing him. As I told you yesterday in the video where I mentioned how Baldoni Lively was not deposed earlier this week, even though she was supposed to, she has been reluctant to hand over any information. And so has he. Let's keep it fair. Remember, I'm not Team Baldoni. I'm clearly not Team Delulu. I'm Team The Truth. Both parties have been dragging their feet. And in the letter just filed to the court, Jen Abel says that she first subpoenaed for the Vanzan documents, including the original Vanzan subpoena. The new Vanzan subpoena was served in April, months ago. And so far, nothing. That's why she's gone to the court asking for a motion to compel. Hopefully the court says yes. In this adorable letter drafted by Ellen Garofalo, who used to work at Taylor Swift's law firm, they tell the judge they already narrowed down the original requests for production, so they're being good partners, and the garden variety actress and her team still has not handed over anything. Remember, the Vanzan subpoena 1.0 is the anonymous lawsuit filed by Cryan Ryan's wife that allowed her to get all of Jen Abel's communications without notifying Jen Abel or Justin Baldoni or any of the Wayfarer parties. In this new motion to the judge, they say, prior to Jen Abel's scheduled departure from Jones's employ, Jones seized Abel's cell phone and accessed and downloaded the contents. In anticipation of litigation against Abel and other Wayfarer parties, Jones collaborated with Blake Lively to contrive a mechanism for Lively to obtain the data that Jones had pirated from Abel's phone and cloud accounts, including confidential and privileged text messages, which are the centerpiece of this dispute. This was accomplished through a subpoena issued in a sham action captioned Vanzan versus Doe's 1 through 10. Abel is informed and believes that Vanzan is a shell company owned and controlled by Lively and or her husband, Ryan Reynolds. The facts speak for themselves. The Vanzan complaint asserted only a bare-bones breach of contract claim, bereft of factual allegations against 10 Doe defendants who, although parties to an allegedly breached contract with Vanzan, were never named or served. There is no conceivable link between Abel and Vanzan, fact, or the unspecified contract that the Doe defendants allegedly breached, fact again. In other words, Vanzan had no discernible need for the information Jones obtained from Abel's cell phone. Correct. After the Vanzan subpoena's return date, the Vanzan action was dismissed without any other proceedings and without ever having requested the assignment of a judge. They just needed a legal excuse for her to have the texts and emails, which she probably already had. The Vanzan subpoena opened the door for Lively to obtain the documents Jones extracted from Abel's phone without notice to Abel or the Wayfarer parties, against whom Lively intended to use the information. Lively procured at least some of the information during discovery, confirming that the Sham Vanzan action was successful in facilitating the transfer of Abel's data to Lively's prior to the filing of Lively's claims against Abel and the Wayfarer parties. Lively's lawyers have publicly acknowledged and defended the Sham Vanzan action and subpoena, declaring that there is nothing untoward here, just conscientious and thorough investigation, and characterizing the Vanzan action and subpoena as common tools that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities. No. Arguing the ends justify the means, Lively's lawyers admitted the Vanzan action and subpoena enabled them to access Abel's text messages. Such tactics are hardly common or appropriate, whereas here, the lawsuit is a sham. The subpoena is intended to obtain information irrelevant to the proceeding in which it issued, and most egregiously, the purpose of the subpoena was either to obtain privileged and confidential information without notice to Abel or to cover up Jones's poor disclosure of Abel's confidential and privileged information to Lively before the subpoena was even served. Abel remains in the dark as to whether Jones actually produced documents in response to the Vanzan subpoena, or whether the Vanzan subpoena was merely a smokescreen to conceal Jones's prior disclosure of Abel's information, the conduct at the core of Abel's claims. So that leads us to where we are. Abel has now subpoenaed Vanzan for documents relating to the Vanzan subpoena and release of Abel's stolen information to Lively. They tell the judge they've narrowed the original subpoena request, and they still can't agree. So they're asking the judge to intervene, hence the motion to compel. They explain to the judge the specific issues that Vanzan has, Van Sham, and then they make their claims as to why those issues are factually unsound, citing cases and the law. So, for the foregoing reasons, this court should order Vanzan to comply and produce the requested documents without further objection or delay. And here's the thing, why I'm not that excited. Even if the judge grants this motion to compel, I don't think it will produce a smoking gun. I don't think it will drastically alter anything. I could be wrong. I hope I'm wrong. Do you think I'm wrong? If so, let me know how in the comments section. The only possible thing I can think of is if Lady Rugpool was literally scheming with malice, putting it down in an email or a text that they're going to make up claims against Justin Baldoni or some evil scheme. Maybe they did that in person. Stephanie Jones and Bully Lively both live in New York and could have met up and discussed things without a paper trail. But we'll see. Speaking of a paper trail, today, Lyerly's lawyers have submitted a document to the court. They are asking for her initial disclosures to remain confidential and protected, sealed. Additionally, Matthew Mitchell, that former JonesWorks employees, has now been served his subpoena, though not through traditional means, served via LinkedIn, as well as by phone, voicemail, message, and on the door of his last known residence. And finally, the shampoo company owner has taken to the courts in Los Angeles to try and compel the Wayfarer third-party employees to hand over the information that she requested in their subpoenas. And they have not yet. I'm not optimistic about anything right now. Thoughts on everything? Let's discuss in the comments.